Good morning, everyone. I want to begin by thanking the organizers for inviting Child Rights International Network to contribute to this webinar on climate rights of children in Europe. Today, I will present the research from CRIN's report, Children's Access to Justice for Environmental Rights in the European Union. This presentation is based solely on the content of this report and focuses on how EU law and institutions shape children's access to environmental justice. This report is a collaborative piece of work, and I would like to acknowledge the contribution of Phil Fisher, the external reviewers, and CRIN colleagues who supported the research. On to the next slide, please. So to give you a bit of context, this report published in December 2025 is part of a wider CRIN project examining children's access to climate and environmental justice across 45 countries, including 13 European states and one region, the EU. The project examines how legal systems enable or hinder children seeking remedies for environmental rights violations. The report considers four broad questions. First, how law protects or fails to protect children's environmental rights. Second, how children can currently access courts in environmental cases. Third, what courts can do when children's rights are violated. And fourth, how civil and political rights affect children's ability to protest and campaign on environmental issues. On to the next slide, please.
I have to fix something. I'm sorry.
No worries.
Yeah, with the screen. Unfortunately, someone wanted to be admitted, and for this reason, I needed to.
No worries at all. If you want, I can keep going, and then when you're ready.
Oh, yeah, please. Thank you.
So to start with the basics, how are environmental rights protected within the EU law? If we look at the European Union, EU primary law does not expressly recognize a standalone right to a healthy environment. However, the Treaty on the European Union identifies both a high level of environmental protection and improvement of environmental quality as core EU objectives. Worth noting that the EU has a shared competence on environmental law and that the EU's scope for action in environmental policy is limited by the principle of subsidiarity, the principle of proportionality, the requirement for unanimity in the Council in certain fields. Articles 11 and 191 to 193 of the Treaty of the Functioning of the European Union are especially important. This is because they define EU environmental policy objectives, including protection of human health, responsible use of natural resources, and protection and improvement of environmental quality. Additionally, the EU's environmental policy is shaped by the precautionary principle, the principle of prevention, the principle of rectifying pollution at source, and the polluter pays principle. Under the Charter of Fundamental Rights of the EU, Article 37, as pointed out by Astrid earlier, reflects the principle of ensuring a high level of environmental protection and improvement of environmental quality. This is framed as a principle rather than a directly enforceable subjective right, but it can still be enforced against EU or national authorities. It's worth noting that although the European Parliament supported recognizing a right to a healthy environment in 2021, formal recognition has not yet occurred. The Charter also states that children have the right to such protection and care as is necessary for their well-being. Moving on, the EU and all member states are parties to the Aarhus Convention, and it is central to environmental justice in Europe. It warrants three procedural rights, which are access to environmental information, participation in decision-making, and access to justice. Although it doesn't make specific reference to children, there has been an increasing recognition within the Aarhus processes of children's vulnerability, barriers to access justice, and risks faced by children environmental defenders. The Convention has been implemented in the EU through several legal instruments on environmental information, participation, and review procedures. In recent years, the European Green Deal has provided the main framework for environmental and climate litigation, and EU secondary legislation is extensive and covers air, water, waste, biodiversity, industrial emissions, chemicals, and climate change. Policies specifically addressing childhood exposure to toxic substances remain insufficient. Important instruments such as REACH and the CLP regulation do not adequately provide clear pathways for affected individuals, including children and communities, to seek remedies when chemical pollution or contamination occurs, including where companies or member states fail to comply with their obligations. Beginning with the Commission, rather than strengthening these gaps, there are also growing concerns that the EU institutions, beginning with the Commission now, yes, are moving to roll back important environmental health protections and corporate accountability requirements. Please note that the information regarding REACH and the toy safety regulation contained in the report is no longer up to date, unfortunately. Our latest understanding is that the Commission may be considering shelving the planned revision of REACH. And on the other hand, the toy safety regulation was revised at the very end of last year. On another note, ecocide is not recognized as a standalone crime, though the updated Environmental Crime Directive covers severe environmental destruction described as comparable to ecocide. Although EU secondary legislation contains few explicit provisions on children's environmental rights, all member states are parties to the EU to the Convention on the Rights of the Child. And in General Comment number 26, the UN Committee affirmed that children have a right to a clean, healthy, and sustainable environment. And those principles remain relevant in areas falling within EU competence. This is also reflected in the 2024 Commission recommendation on integrated child protection systems, which encourages member states to protect children from climate and environmental harms, involve them in decision-making, adopt child-sensitive climate measures, and address climate-related migration through a child rights approach. Lastly, the Court of Justice of the European Union has played a major role in developing this environmental law. It has interpreted directives, treaty principles, enforcement obligation, and procedural rights. Although the Court of Justice has not explicitly recognized a standalone fundamental right to a healthy environment under EU law, its case law has strengthened environmental protection and public enforcement. No major judgment has directly centered on children's environmental rights, but many decisions have had clear relevance for children because they strengthen environmental protection. We set out the case law in full in the full report if you want to explore it more. On to the next slide, please.
I wish I knew how to, but sorry, I'll fix
It's fine. I'll keep
Sorry.
going. I'll keep going. So alongside the broader legal framework, a number of practical issues affect whether children can access environmental justice effectively within the EU. Now let's move on to the practical challenges that children might face when seeking justice for environmental rights violations in the EU. First, we have costs and access to legal aid. The European Union does not generally provide direct legal aid for environmental cases. Access to legal aid is primarily governed by national law, meaning that availability, eligibility criteria, and procedures vary across members. However, the EU and international frameworks recognize the importance of reducing financial barriers. For example, the Aarhus Convention calls on parties to provide information on review procedures and to consider assistance mechanisms that reduce financial and other obstacles. The Charter of Fundamental Rights also provides that legal aid should be available to those who lack sufficient resources. And in cross-border disputes, there's a directive which establishes minimum common rules on legal aid for persons without sufficient means. In practice, this means that access to legal aid in environmental matters depends largely on domestic systems rather than a single EU-wide scheme. As a result, financial barriers may differ significantly between member states, and children are rarely in a position to afford legal advice or representation, yet it is essential if they are to be able to access and rely on justice systems to provide remedies for rights violations. Second, we have standing. Standing rules are often decisive in determining whether environmental claims can be heard at all. For example, before the Court of Justice of the EU, individuals, including children, must generally show that the contested act is addressed to them or that it is of direct and individual concern to them. Direct concern generally means that the measure directly affects the applicant's legal position and leaves little or no discretion in implementation, while individual concern requires the applicant to be distinguished from the general public by particular characteristics or circumstances. This has been described as particularly strict requirement, illustrated, for example, by the People's Climate case, where applicants were unsuccessful on admissibility grounds. Before the European Court of Human Rights, applicants must generally show that they are personally and directly affected, that domestic remedies have been exhausted, and that the application is lodged within the required time limit. For children, the formal standing rules are generally the same as for adults before both the Court of Justice and the European Court of Human Rights, and children are rights holders in their own capacity. Although many cases involving children are brought by parents or other representatives, there is no bar on children themselves making applications to either court. Council of Europe child-friendly justice guidelines also emphasize that children's right to have their own legal representation where conflicts of interest arise and their right to be heard. At the same time, applying identical standing rules does not necessarily produce equal access in practice. Children may be more acutely affected by environmental degradation and climate change because the consequences of present decisions can unfold over decades. Yet, requirements such as individual concern have still limited attempts by children to pursue environmental claims. Specific standing rules concerning children should be encouraged in this context. So when standing has been established and children have a foot in the door, one of the next big challenges is who has to prove what and to what standard. This can be a particular challenge in cases related to children's exposure to toxic chemicals and pollution, where harm may emerge only after many years. In practice, the burden often falls on victims to show a clear link between the environmental exposure, the alleged polluter, and the health effects suffered. Before the Court of Justice of the EU, actions for damages against EU institutions generally require proof of three cumulative elements. First, a sufficiently serious breach. Second, an actual damage. And third, a direct causal link between the previous ones. Before the European, what I wanted to say is that this sets a high threshold and can make such claims difficult to establish. Before the European Court of Human Rights, successful environmental claims have also depended on demonstrating a clear connection between the harmful activity complained of and the impact suffered by the applicant. And then where causation is not established, claims are very unlikely to succeed. For children, these evidential requirements can be especially challenging because establishing long-term effects, future risks, or cumulative environmental harm may be harder to prove precisely because the consequences unfold over time. Thus, consideration of measures such as reversing the burden of proof in appropriate contexts should be encouraged. Building on what we've just discussed, children still lack access to adequate age and disability responsive information about the effects of environmental harm and climate change, even though accessible information is essential to participate and access justice as acknowledged by the UN Committee on the Rights of the Child. At the EU level, access to environmental information is principally governed by the directive that implements the Aarhus Convention. It gives the public a right to request information held by public authorities who must generally respond within 1 month, subject to limited exceptions, of course. Environmental information is defined broadly and includes data on air, water, soil, biodiversity, emissions, waste, environmental policies, risk assessments, and impacts on human health. EU law also promotes the active dissemination of information, meaning authorities should not wait for requests, but should systematically publish relevant environmental data through digital tools and public databases. For children, there are no formal age exclusions, but practical barriers remain. Information may be highly technical, difficult to understand, inaccessible for children with disabilities, or dependent on digital consent rules under the GDPR. Within the Aarhus framework, states have therefore been encouraged to develop child-friendly formats and improve access to information on pollution, chemicals, and environmental risks. On this, if appropriately elaborated and curated in line with and respect of children's rights, pollution information portals can constitute powerful tools to provide information. However, the European Pollutant Release and Transfer Register does not take into account child-specific factors in terms of which data is gathered and the type of data generated. Environmental education, as mentioned by other presenters, is also crucial for children to properly understand what climate change, pollution, hazardous chemicals, and their environmental rights are. Several EU initiatives exist, but significant gaps remain in ensuring that all children can engage effectively. A final practical challenge I want to highlight is the issue of limitation periods or strict deadlines for filing cases. There are no environmental case-specific limitations periods before either the Court of Justice of the European Union or the European Court of Human Rights. Instead, general procedural time limits apply, and this can determine whether a claim is admissible. Before the Court of Justice, relevant time limits generally range from 2 to 4 months, depending on the type of action. And before the European Court of Human Rights, an application must generally be lodged within 4 months of the final domestic judicial decision. The European Court of Human Rights has also recognized that in some cases involving medical conditions, limitation periods should take account of situations where it was not scientifically possible for a person to know earlier that they were suffering from a disease. Strict limitation periods are particularly problematic for children whose ability to approach the courts depends on parents or representatives, or may be delayed until they reach the age of majority. In addition, the health effects of environmental harm often take years to become apparent or are hereditary, making it harder to build a strong case. On to the next slide, please. So taken together, these practical challenges show that access to environmental justice depends not only on the legal rights in principle, but also on whether procedures are accessible and workable in practice for children. This has been a very, very condensed overview of a much broader report. The report explores these questions in much greater detail, including specific legal frameworks and case law. I hope, nevertheless, it was helpful in illustrating the key challenges and opportunities surrounding children's access to environmental justice in the EU. Thank you for your attention.